calling the zoning board of appeals meeting for June 9th, 2025 to order. We are live at Wilcott Commons and we also are on Zoom for anyone who wants to participate remotely. We only have one new hearing on the agenda tonight. It's an appeal of the building inspector's decision at 380 Chief Justice Cushing Highway. The applicant is Stoked Pizza. You're speaking for the applicant?
I am.
Okay. Do you want to use the lectern? There's a microphone there, Mike.
I will, if you need me to. I hate public speaking, so I'm already nervous as it is, so.
Well, since the people
Yeah,
are,
no, fair enough.
so could you identify yourself? And
Yeah, Doug McGregor, 2nd Water Street, is where I live. My name is Salty Days and also Stoked Pizza, which we're here to talk about. Would you like to begin?
Yes, please.
So you have in front of you my appeal, John's rejection, probably one of the thinnest and lightest bits of paperwork we've had to look at. That's by design. We want to stay focused on what I'm here to appeal. We're not proposing to build a sign, place a sign, looking for approval of a sign. I know it's a non-conforming sign. The only thing I want to talk about tonight is the rejection, which was only based on one thing, which was the inability to have 3 signs at a business. That's all I want to talk about, and I'm hoping that's what the scope is, and that's what I've got some advice on, just trying to keep it to that. We would like to have a 3rd sign. The current zoning for signage allowing only 2 signs to be one size fits all for a 100 square foot shop or a 5,000 square foot shop, 2 signs, no more. Okay, I like that gives you guys the oversight to say what's more logical, and that maybe some businesses deserve a 3rd sign if it's logical. And that's what I'm here to hopefully stick with logic and common sense, a little bit of precedent, and not get into the onerous for a small business like ours, requirements of site plans and lawyers and this. That's why I'm here standing nervously in front of you trying to make my case as best I can. As a business person, the 3rd sign, why we think we might deserve one, where others might should be limited to 2. I put in my appeal. Background is that we did purchase the Feng Shui business, which had the right to 3 signs in the past. They've been using that sign has been in use for 48 years, but the fact is they had 3 signs for 20-something years. We purchased all their rights. We didn't lease the space, we purchased the business, we named it. We'd like to use the attributes of that property that were assigned to us when we purchased that business. I put in the purchase and sale, we purchased all the rights to signing. If that's not relevant, we also call upon, we notice the precedent up and down that area, that highway business corridor, is it? That larger businesses seem to be logically granted 3 signs. That included a bunch of pictures of banks, Stop and Shop, Curtis Liquors, places where 2 signs might not be enough. Aesthetically speaking, we don't want to get into how big our 1 sign could be with the frontage and whatnot. We think our proposal is more logical. We have a tasteful sign. It's about 21 square feet hanging there. We want to use less than what we believe we're entitled to under, the square footage frontage, but aesthetically also, from a common sense or logical standpoint, we are on the intersection of 2 roads, and we would like to have a pretty clear understanding, coming particularly from the north, of what the business is behind that. To date, we've been required to keep that sign blank. It's got a white piece of vinyl over it. People are asking what's wrong with that. It's been a little bit of a hardship. We're trying to launch our lunch business, and right now we'd really like to use that sign to highlight that. So, based on those things, we're hoping that we can stay away from a lot of technicality stuff and fall back on logic and common sense, precedent, leasing rights, purchasing the business, and hoping that you guys might agree that that sign was used for all the, not that particular physical sign, but a 3rd sign for this location being 50, we're all in about 5,600 square feet, would be something that you would have the purview or oversight to allow a business of our size to do, as has been done for other businesses in the area. That's really what we're getting at here. If have to discuss.
There's a couple of kind of threshold issues that I think we need to think about. The first is John's role in issuing building permits is to make sure that they comply with the bylaw. And if they don't, he doesn't have the authority to grant building permit. And if he does, someone can appeal it to us and we'll hear it. What John has done so far is to comply with the bylaw. So I do think that probably the proper avenue for you is not so much an appeal of his decision, but an application for a variance. Because that's essentially what you're looking for, is a variance from the existing bylaw. This particular property's come up several times for different variances and requirements, which kind of leads me to the second issue. In previous years, when the property has come up with an application for a variance or any other kind of permit, it's been one lot, one property. The property is now 3 properties. So just looking at the signs now, it looks to me like the small pylon for the Stop and Shop isn't on the Stop and Shop lot. It's on the lot for either the building out back or the building near it. The pylon for the other businesses is, I think that pylon eats up most of the allowable sign, if not all of the allowable pylon sign square footage for that particular lot. I think you have an issue with the landlord as much as with the town. And I don't, that's nothing that we can resolve. I do understand what you're trying to do and why. And I understand as other business owners in that particular space have come to the board at different times looking for a variance on signs because of just the same problem you have. It's beside space, but the frontage is here or here, but not both. The other problem that I have, I can't, from the papers that we have, I can't really tell what you are asking for as far as signage. I know you showed, there's a lot of pictures in here of buildings that have 2 building signs and a road sign pylon. I didn't see any that have 2 road signs and 1 building, 1 on the building. And I think that what you're looking for is 2 signs on the road and 1 on the building. Is that right?
Yeah.
Okay. So there's a lot of kind of issues that we need to discuss. It's really not as simple as an undertaking as it seems at first.
Yeah, I'm only here to repeal the decision, which was it's rejected on this basis alone, that you're not allowed to have 3 signs.
Right.
Or didn't specify what kind, or what dimension, what it would look like. That would be something we'd have to work out in our permit, but just not be allowed to have 3 signs.
Well, I think in looking at these signs, my first reaction is there may be a lot of illegal signs there already.
Yeah, I'm not the landlord.
Just because of what they've done with the lots and everything, but that's something we'll have to take more of a look at. But that's all I had to talk about at the moment. Does anyone else
I'd
have?
say if there are illegal, I think there are a couple of illegal signs, including the wine and spirits, which is not your business. But if the feng shui sign was illegal, that doesn't give it any standing. It doesn't make it protected as grandfathered. It's an illegal sign. And so you'd have to apply anew, as opposed to say, well, some other institution put up an illegal sign. I mean, they didn't get our permission, and we're the people who give the permission.
Yeah, I could not convince the landlord to come, or I should say that, he's not here to defend. I understand that time's been through the ringer, state court back 1948, that it exists as get the right to lease it to me, and that's, where I stand, and it's in my lease.
Well, I'm sure he has a right to lease you property. just doesn't have the right to grant you sign permits.
In fact, the permit that allowed him to put up the pylon sign that's there now, when the original Stop and Shop was built and that building was built, part of the decision was that he had to take down that other sign, and he never did. So it's kind of a mess. I kind of think that probably the whole sign bylaw could use a little bit of a review. As there are unique situations, or even if they're not all that unique situations like yours. But we're not at that point right now. Charlie?
No, I think you stated the issues very well. I have no addition to add.
Lee?
No, I'm just that we've had comments, for the past 5 years at least, when people about that song.
Yeah, no, like I'm stuck in the middle.
I know,
Yeah.
we get anonymous letters and then some other letters saying, why is that sign still there? So it's somebody's,
Yeah, no, we're aware.
Yeah, I guess I have one issue is, you're asking us to overrule or, the building inspector's denial. And, what would result from that denial? He's not giving you a building permit because, or a signage permit. We could have, overrule his denial, but that doesn't mean we're approving it. Not a thing.
My understanding was that my application was denied only on one basis, which that there wasn't allowed a third sign. Otherwise, there wasn't any objection to it, and that's where I came here.
Right, so you could not get a third sign from John on this one.
I'm not sure if I follow the,
Well, John doesn't have the authority to give you a variance. Only this board can, so you can have two signs, possibly. There is another issue there, and that is that have the requisite 40 square feet already been used up on a pylon on this lot? I don't know.
is that somewhat vague in the zoning? Is it for tenant, for property, for?
For property. But one of the things that occurs to me is that there's no sign right now on the Stop and Shop lot. Stop and Shop sign, the small one, is on either the lot for your building or the lot for the back building. And big pylon sign is definitely on that particular lot. So it seems to me that the amount of allowed signage on that particular lot is already up. If that sign moved, then obviously there'd be more available signage space.
Yeah, I'm unaware that there's even 3 addresses. I haven't seen a site plan.
Yeah, we didn't know that until John told us tonight.
Yeah, give the tenant saying, you heard what I said, so, yeah.
But that may be to your advantage. I don't know. Matt?
No, not much to add. I guess to your point of like logic and common sense, sometimes, we can't apply that theory, right? Because we're kind of stuck to this bylaw book, and
Yeah.
I think it would, like, when you look at the past history, a lot of the board has says we'd be providing a grant of like special privilege if we did that, and then kind of where does that end as far as that corridor is concerned?
And that was the hopes, that it was step back and look at this thing as a standalone issue. It's like, okay, this has been the big restaurant on the corner for a lot of years. This restaurant always had the sign on the corner. Not talking about advertising something down at the harbor, which I understand was a problem in the past, but this was Feng Shui sign. We took it over. We want people to know our restaurants there. We're not using more square footage than they were. But yeah, that's where my expertise in all this ends. I don't know site plan or building addresses. I just know it had 3 signs. We bought it, like to keep using 3 signs. Not setting any precedent, not having anything that would survive my tenancy there. Just saying, yep, that sign belongs to that restaurant. We'll give it to them. If you move out, the next person doesn't have that right to use it. Something that wouldn't be setting a precedent for you guys, but just saying, yeah, logically, you want to support the business, you want to have the signage that is logical.
Well, there is an axiom in zoning that there's no such thing as precedent, really. Every situation is unique, but in the 90s, 6 times, various tenants came before this board and requesting signage on Sawyer Street, and 6 times they were turned down. And those are the only denials that we have in our files. So it was turned down time after time after time. And if a failure to enforce an illegal sign or remove an illegal sign, that's not this board's role. We're, as you know, we're a board of appeals. You can come to us and appeal, but we're not an enforcement agency that goes around town, you know, asking the building inspector or other people to take action. So the fact that people didn't come, you know, a franchisee or business owner didn't come to this board seeking relief doesn't benefit you or anybody else. I mean, it was just a failure to enforce. And I don't know.
Michael? Anything?
I guess I'm sympathetic, you're buying a business, they had 3 signs, all of a sudden it's like have the rug pulled out from you, but I guess some earlier said that may be a problem with the wording of the bylaw. And more than anything else. Bylaw is the bylaw, I am sympathetic though.
Yeah, I am with myself as well. No, no, and and again, having read the bylaw at the peak of my job description, be able to read through that, but it seemed light in terms of giving you guys more ability to apply common sense with, like I said, maybe that's not always there.
It seems to me you'd have to do some more homework along the lines that Dave has suggested. You'd want to know what, and it's actually your landlord that owns the frontage and has the right to signs. You don't have any right whatsoever to have a freestanding sign unless he, grants you some of his rights.
Which he didn't, yeah, this sign is specifically granted to us in our lease.
But if he exceeds, I don't know if he does, but if he exceeds what he's allowed to do, then that's null and void. That element of the lease, as Dave said, is probably between you and the landlord. But the first thing I would recommend you doing is doing a statistical assay of this property. How much frontage does your landlord have? Has he used it up or not?
Well, that's actually maybe an issue between John and the landlord
Yeah,
at this point.
How lots are split up, frontage of each.
Yeah.
Lot, the lots being each building.
but I think that needs to be looked at carefully rather than have a proliferation pylon after pylon, just because there are more tenants.
Again, I don't have a lot. How it's split up. It just I knew it was split up when we received some of the information at one point. Basically, and also with the Board of Health septic system.
Well, I was just
The shared system.
I was looking at the assessor's map and there's a big stretch of frontage on the highway in front of the Stop and Shop building. There's a narrow one that includes the entrance to the whole thing that goes to the back building. And then the rest of it and around Sawyer Street is all that building.
Yeah, that's kind of.
I would also say that this doesn't apply to Doug, but the Wine and Spirits Depot has that big sign over the Stoke sign, which is the liquor store down there. The David Hassan drawing shows Stoke sign being roughly 25.2 square feet. By every visual indication, the Wine and Spirits exceeds that 25-foot size. So that particular operation would be in violation
Size.
on size.
Mhm.
There is, I don't think they're in I don't think they're in violation of, the issue of setback. No sign may be located closer than 15 feet from any property line, but it's worth seeing that, you know, engineered out. Because I don't know, so it's pretty close, but probably okay, but yeah. I don't know about height. I don't think it's 20 feet tall.
No, if I understand.
Yeah. But
I'm just thinking, I mean, I don't think we have any choice but to deny the appeal.
I hear it going that way.
Okay, I'm
But
just-
As a resident, I just know I'll do a good job with the sign. I mean, it's gonna be, God knows it's there.
Mhm.
And there are powers that be behind it that say that's not going anywhere. If it's not me, it'll be someone, if it's not someone's third sign, it'll be someone's first sign and maybe it's separate art. So I know I can do a good job with it and do something attractive on it. It seems to follow logic, but like I said, yeah, you have to do, but be a decent steward of it. Something, you know, attractive and logical. The restaurant that sits right behind it. If you have the power to do that, I would appreciate it. If you don't, I would understand it. No hostility, but I'm caught in the middle here, that we leased it, we paid for it, and several times over, buying it, leasing the property and all that, but also, yeah, or it has the ability to say, yeah, big 6,000 foot place could have a third sign, and it's that simple. Then
Yeah,
I'd love it.
We can't do that one, but I am concerned. I don't want to prejudice anything else that you might want to do by denying the appeal. And I don't think that there's anything, Woody,
what?
if we deny the appeal, would that impact any other applications that he might want to make, like for a variance?
I assume we could deny it without prejudice.
Okay,
If we deny it or deny it with prejudice, then he has to wait 2 years.
yeah, we don't want to do that. Yeah, you can do that.
Yeah, you could withdraw it.
Just withdraw the appeal.
Yeah, and just one other question, too, but might lead into what he's talking about. With an address or a directional sign with no business on the sign, would that be allowed as an independent sign in that area? 380 CJC, next slide.
Uh,
I know it's kind of hypothetical, but I'm just.
There is a directional sign
yeah,
provision.
where is it?
Directional signs are an exception. Signs that are allowed as of right, directional signs, provided such signs do not exceed 1 square
1
foot
square
in
foot.
area.
So that'd be
Square foot, okay.
pretty
It's
small.
kind of small one, yeah,
You know, one size fits all for everything.
right, yeah.
Might be for Seamstress shop in the village, but not for
Mhm.
shopping center.
Yeah, and you can occasionally do like temporary signs, like you mentioned, like if you're gonna launch business for, open for lunch, you can have those out there for like
Yeah, we did that.
up to 30.
Yeah, he's got a
And we-
30-day.
There are other signs with them.
There's a 30-day limit to the present banner there, which you can renew, I think, once. Is that correct?
And there's no banner there.
Once.
Once we had our permanent signs up, we blanked it out. It's just white vinyl. Gets a lot of questions. You're saying, when you get your sign up.
Are we talking about the same thing?
I think he's talking about the sign.
Yeah, he's talking about the Sawyer one.
Okay, and I'm talking about the banner that's underneath. the
Oh,
stores.
they didn't open for lunch and that's coming up on 30 days. Yeah. Yeah, that's coming down. I believe you have another application for that area to be used for signage by that landlord. That's all I heard.
And probably not the same. Full banner signs, they hung one on that area too, so just kind of skirting around the issue they probably need to relief.
Yeah, this is again, not for Doug, but that there's another sign, temporary sign, coming soon, open for breakfast and lunch. I don't know if they'd want to use their 30 days plus 30 days up with that until they kind of reach the date of opening, whenever that may be.
I think that probably just try.
Oh, okay. Well, that's a moot point.
I haven't stopped there.
No, that's fine. I mean,
Yeah.
it's up to them.
Perfect.
So if the goal right now is to not prejudice anything future, I should probably withdraw my appeal of John's denial.
Yeah, we can do that by motion here, just to allow you.
Let's do that and go back to zero.
Okay. I'd move that the,
So.
Confirming that you're agreed, you're agreeable.
Yeah, and that kind of brings us back to square one. No harm, no foul. All right. On a small business budget, this is what we tried, so.
I know,
Right, and probably variance or have a little more complicated than they were even like, so. All right, so that's what. I'll withdraw. More formal than that needed besides.
I'd move that we accept the applicant's withdrawal without prejudice.
Second.
Okay, any
Say
discussion?
that again.
We accept his withdrawal without.
Oh,
prejudice. Any discussion? All right, all those in favor?
Aye. Charles Higginson.
Dave McMorris, aye.
Matt Watkins, aye.
Woody Chidick, aye.
Mike Dickey, aye.
Darcy.
Why not?
Thank you.
Reference. It's gonna be a good place, but those are good guys too.
Are they?
Yeah. Where Papagino's was?
Oh.
Yeah, it's an operator that I considered helping years ago, but he was not needing help when he opened his current place, but two brothers, great family, great people. They will do the thing there.
Both your places are great.
Thanks, yeah, they're going well. They're like the full disclosure, like we want to build a lunch business. That's one reason the sign, you know, have people driving and saying, oh, I got a couple hundred feet, I can turn left and get, and we're sort of missing that right now, so we want to build that a little bit, but. Regrouping. See you again.
Okay. Don't. All right,
Yeah. All right, not the outcome we wanted. Fair enough. Thanks for treating me kindly.
Thank
Thank
you.
Have a good one.
Thank you.
two.
It's nice to meet you. Thanks
You
for
as well.
investing in Cohasset.
Yeah, I'll keep doing it. See you guys.
All right, we don't have any closed hearings to deliberate. Our next meeting is Monday, the 7th of July. Is there any other business that we need to conduct tonight? Is there anybody on Zoom that wants to speak about anything?
No news or reads, but keeping on those.
Okay. Well, anyone want to move to adjourn?
Yeah, well, just before we do, John, I think this probably brings up that bigger issue of signage. I think you should, my recommendation would be to step back, take a look at the frontages, take a look at the square footage of what exists already, and that would help everybody out, including applicants who
Yeah.
might want to negotiate with a landlord or something if they get closed out.
And there might be signs on properties where they don't belong.
Yes.
Yeah,
Without.
All right,
okay.
What's an identification sign?
Question?
You have it?
Identification sign?
Yeah,
Oh, that is the street number? Is that-
no sign,
business
but
name, no.
except a posting or an identification sign.
What section is that? Six what?
300, six one, yeah.
6-4?
Yeah, one identification sign. I assume it's a identification is business name, right?
Yeah. I would even think with that at the act. Identification. Say the size.
6 square feet. So not very big.
Section
66A4.
6-6-A-4. Okay, one identification, you're right. In front,
Not much more than a nameplate, I assume.
yeah.
Yeah, maybe 2 feet by 3 feet. That's almost like the, a lot of the signs you see for contractors. About that size. You know.
Well, that's the front entrance to each building. It might be almost like when you walk in.
Yeah.
Did you make a motion?
I didn't. I invited a motion
I'll move to adjourn the hearing.
for a second.
I'll second.
All in favor? Charlie?
I,
David Morris, aye. Matt?
Aye.
Woody?
Aye.
Lee? Mike?
Aye.
Aye.
All right. We're adjourned.
Wow.
Pretty quick. Been a
Yeah.
while.
That probably, I think, sets a world record.